The last myth, and I've talked to this group about this when the case came out back in January of this year. As probably some of you have known or read about, the Supreme Court of the United States came down with a decision in January of this year involving the ministerial exception, which all religious organizations sort of use that as their first thought is, oh, none of these laws apply to us because, you know, of what we do, and then they say, then I disabuse them of that, which is actually kind of fun from time to time. And they say, well, that we've got this wonderful ministerial exception, so I'm sure, you know, this person who has a beef with us falls within that exception. And the decision by the Supreme Court in the Hosanna matter was a victory, but a very small victory for religious organizations. It's, I won't bore you with the facts. It essentially involved a teacher who developed a condition called narcolepsy, which is a covered, it fits within the definition of disability under the Americans with Disabilities Act, which is a law that applies to any company, here church, that has 20 or more employees. So that's probably lots of you, and obviously lots of companies out there in the world. And so there was this big battle. The church said in the case, hey, well, this teacher is a minister and falls within the ministerial exception. It kicked its way up through the courts of appeals and in the federal courts. Ultimately, the Supreme Court heard the case and said, we agree. This teacher has no right to sue you because we consider her a minister. But it's super, super narrow. All the Supreme Court did was say, yes, we agree that this ministerial exception exists. We recognize it. We've recognized it for many, many years. It was a 9-0 unanimous decision. But when you look at the decision, it doesn't decide a whole lot. It's very careful. They articulate no test for going forward as to when somebody's going to be considered a minister or not. They talk about, you know, let's say 15, 20 factors that existed in this particular case. They don't put them in any order of priority, like we think this one's really important and this one's just so-so and this one, yeah, it's nice, but so what you have is no test articulated by the court. They completely ducked that, so there's no guidance now going forward. And they've limited it to, the teacher brought a claim for, and this is very technical and I apologize, for discrimination and retaliation under Title VII. And what the court basically said is, well, we're going to save all these other things for another day. We're just deciding based on these types of claims brought by this particular teacher, based on what she was doing at this particular school and what her training was, that she loses. So the same teacher could have a breach of contract claim, could have any kind of tort, which is a physical injury claim, which wouldn't be covered by anything the Supreme Court said in the Tabor case. So